Welcome back to another episode of the Business Immigration Benchmark. I'm your host, Laura Blanears. Today, we're chatting an emerging adjudication trend coming out of USCIS. So, we're recording this episode April 24th. And as of last week, April 14th, a new RFE trend has emerged. And while it's still developing, I thought we'd use the time here to discuss what we're seeing. And while I can't give legal advice, this is not legal counsel. Of course, I can give you a framework in which to think about this developing RFE trend and how to ask some questions, prompt some conversations with your counsel to get the support you and your program needs. So, the new RFE trend that's just emerging is requesting current addresses and also requesting biometrics collection. So, what we know is these RFEs are being issued in the employment-based context in H-1B extensions and I-140s. Now, it's not known that it's exclusively these things. That's just where our firm, as well as the immigration bar and AILA, is reporting these RFEs being issued. The RFEs state something like, we have encountered potentially adverse information related to the beneficiary. To continue processing your application or petition, we require an updated address for the beneficiary so we may collect biometric data. Please submit the beneficiary's current and updated residential address. In other instances, the RFE is not identifying this vague adverse information related to the beneficiary, but rather is requesting that the beneficiary come in for a biometrics appointment at a USCIS biometric center. So, a few thoughts to help you think about these RFEs and to consider as you're developing your response framework with counsel. My first thought is that the government is required to disclose what the adverse information is in order to give the petitioner or the company sponsor, in this case, a response to respond. So, that is my first thought and consideration when approaching these RFEs. And again, it'll kind of depend case by case and what exactly is said in the RFE. But just know that if there is some citation to a vague reference of adverse information, the law requires that the government disclose what that adverse information is and give the opportunity for the petitioner or company to rebut or respond to whatever that adverse information is. My second thought here and thing to consider is these inquiries appear to be following the recent data mining issues that are really in the headlines right now in the F1 visa revocation, SEVIS revocation. And so what's come to light in these F1 cases is that the data that the government has uncovered can be categorized into, four different categories. The first is there's sort of no criminal issue, that this is wrong information, and the government's just pulling a file that has no criminal issues. The beneficiary has never been arrested, has never been charged, none of the above. The second bucket is that the beneficiary or the foreign national has some sort of minor criminal infraction, so something like, a traffic citation or a misdemeanor that is not deportable or does not place a foreign national into removal proceedings or does not make them inadmissible. So we expect, as we have seen in the F1 context, and you've seen it in the headlines, that these F1s who received visa revocations or SEVIS revocations have absolutely no criminal history, no criminal arrests, no criminal indictments, no criminal record at all. And so we expect that that would be the same in the employment-based context, that whatever erroneous data mining the government has pulled together, that we're going to see a lot of these cases crop up where there is no criminal record at all for the foreign national employee. In those instances, those are going to be obviously the most straightforward cases to come up with a strategy. When the foreign national employee has some sort of criminal infraction, whether that's a charge or a low level, even if it's a traffic citation, it becomes a little bit more complicated. And that brings me to my third consideration that you're going to want to have with your counsel. And that gets into setting up a framework with your counsel as far as how you're representing or how counsel is representing both the company and the foreign national employee. And if that's possible under your engagement, because most representations when you have a corporate counsel is that the obligation to disclose is to the corporate client. And so if there is negative information, such as a criminal arrest or a criminal record for the foreign national employee, most corporate attorneys are going to have the duty to disclose that derogatory information to the corporate client, the company. And obviously, that might complicate both the relationship of how the employee maintains its employment and also how that's disclosed to the employer. So, just things that you want to be thinking about before you receive these RFEs. Hopefully, you've talked through these issues so that you're aligned with the framework and how your corporate counsel can continue to represent you and if they can continue to represent the foreign national employee, depending on the situation. It's really key that you have this alignment and that importantly, there is notice and disclosure to all parties and moving forward with the representation. So leave it up to you to have those conversations, things to consider during a pretty difficult, challenging RFE trend. At this point, though, as far as advising my clients to sort of broadcast or communicate this RFE trend out to foreign nationals, not advising that yet. There's not much that a foreign national can do at this point. If they're caught up in an erroneous RFE through this data mining, that will be something you can't really predict or prevent at this point. And if a foreign national has a criminal infraction on their record, of course, you can't go back in time and change that either. So there's nothing really preventative that can be done other than having these conversations with your corporate counsel to understand the strategy in responding and how you're going to handle the representation of foreign national employees who may have some criminal infractions. I want to close with a positive or a hopeful note here, and that's the immigration bar here is working very closely on this trend and all other trends that are happening. So that's all to say that, through AILA, through the immigration bar, there's a lot of information trend sharing so as to get on a strong defense here to protect our companies, protect the employees in their status. So kudos to the immigration bar and other practitioners out there. We're hanging tight to make sure that companies and foreign nationals maintain compliance, maintain status in the US. And, what will be a tough 4 years ahead, we're here to make sure everything that we can do is done and working together to make that possible. Thanks for tuning in to the Business Immigration Benchmark. We'll catch you next week.